So I do have Katie Howard in the waiting room as well. Mr. Brugman, I do have one person in the waiting room for paternities, but do you want to start on Mr. Howard first?
Sure.
Okay.
Whatever you like, Judge.
Okay, thanks. All right, so. Okay, Mr. Howard, do you want to have a seat up here?
On the contract, if I go here.
Mr. Howard, all right, so this is in the matter of Katie Suzanne Howard versus Daryl Levon Howard Jr. File number 19-46860DM. Mr. Howard, I'd like you to sit at defense table, and Mr. Bruggeman and whatever witness you might have. Mr. Howard, there is no contract by entering the courtroom. A basic understanding of the law would dictate that there's no contract by having a seat being seated. I know that you're Daryl Howard. I've had jurisdiction.
Right, and
I've had jurisdiction over you before because you had a case for a felony child support case as well as appearing before. So this is the date and time set for hearing in this matter. Mr. Brugman, Katie Howard is in my waiting room. Is she going to be a witness today?
No, it's a show cause for failure to pay.
No, this is a bench trial.
Yeah, show cause bench trial for failure to pay.
Yes.
Yeah, no, I have the front of the court.
Okay. Any objection to Ms. Howard viewing?
No, she can certainly.
Are you calling Katie Howard as a witness?
yeah, I can. Yes.
Yes, okay, so
Um,
hold on. Ms. Howard, I just wanted to let you know we're here. We're gonna start the hearing. Now, if Mr. Howard's calling her as a witness, should I sequester her by putting her in the waiting?
No, it's fine. She can.
Mr. Howard, do you want me to sequester her? She is a party to this, but do you want me to put her in the waiting room until you call her?
yes.
Okay, so Ms. Howard, I'm gonna pop you in the waiting room, all right?
Okay.
All right, so this is the date and time for a show cause bench trial in this matter. Mr. Bruggeman, are you ready to proceed?
I am your.
Mr. Howard, are you ready to proceed, yes or no?
No, I had one thing I wanted to make sure. The original contract that she signed up for, I wasn't a part of. So is that void ab
There
initio?
is no contract in the birth of a child in support of the child, so thank you. Mr. Bruggeman, are you ready to proceed?
I am your.
All right, may I call your first witness?
Let's call Mr. Bot. Mr. Vasquez.
Mr. Vasquez, you want to step up here, please? Mr. Vasquez, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, have a seat, please. Can you state your full name for the record, please?
Jay Vasquez,
And you are employed by?
front of the court.
All right, very good. Mr. Bruggeman?
Mr. Vasquez, could you say your position with the front of the court?
Enforcement officer.
In that capacity, do you have access to the defendant's files and records?
I do.
Is there an order to pay child support?
Yes, sir.
What does that order state?
Mr. Howard is ordered to pay $151 a month. And he is currently behind the amount of $8,298
That's a arrearage as of what date?
today.
And when was the last time you received a payment?
He made a $1 payment on October 26th.
Of this year?
Correct.
And when was the last payment before that?
December of 2021,
And how much was that?
$14.38.
So since December of 2021, he's made a total of about $15 in payments.
Correct.
And how long has this order been in place?
The original order was entered October of 2019, and judgment of divorce ordered that support remains the same. That was March of 2020.
No further questions, Your Honor?
Right, Mr. Howard, do you have any questions for Mr. Vasquez?
Yeah. When was the last time you had conversations with Mr. Howard, the defendant? When was the last time you inquired about the ability to pay?
That's not the front of the court's job.
Are you the caseworker for the defendant?
Yes, I am.
So when was the last time you and the defendant spoke to each other?
On this case, I'm not sure. I don't know if we ever have on this case.
Now, originally in this case, the defendant, when you had the order signed, is that the same day that he was taken into incarceration?
I have no knowledge of them.
So October, okay, so let's go to October 1st, 2019, is that correct?
The original order was entered October 28th of 2019.
Okay.
And you were served July of 2018. This order.
So on October the 1st, because he was incarcerated for 4 days. On that day, recollection shows that the defendant
Well,
and
Mr. Howard, can I first inquire, why were you incarcerated?
for a failure for the case, was there for,
The felony child support case?
was there taking care of
Okay, so
this.
he didn't deal with a felony case, so. I don't
Right,
know
but I'm
that-
speaking in, okay, well, in regards to this case, on that same day, the 2 officers there, that was the time that this was supposedly signed to be a child support order.
I signed the child support, not you.
Okay, well, during that time period, there seems to be a mistake in fact, okay, all right.
I have no follow-up questions for Mr. Brasco.
Have a seat. Any other witnesses?
I have no further witnesses, Your
All
Honor.
right, Mr. Howard, so do you wish to call any witnesses?
Mrs. Howard,
Okay,
stand up.
you can stand at the podium.
All right,
And then she's going to be up there. And I swear in, Ms. Howard, can you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Can you state your full name for the record, please?
Katie Suzanne Howard.
All right, very good. Mr. Howard?
okay. At the time when you, at the time of conception, were you married?
Of what session of the,
Of the child?
So, Mr. Howard, the only issue we're really here on and we need to focus on is the child support and failure to pay.
Correct, but if the child was born out of wedlock, then we have to figure out a different scenario because all
No,
that's not
doesn't make
true.
a difference if she was married to you, married to
That-
somebody else, or not married at all.
All right. Let's see here. Okay, so. Okay. Underneath, Michigan Common Law 700.7901, there's remedies for breach. Violation of the trustee owes the trustee to the beneficiary, which is Mr. Howard, is not of the breach. To compel the trustee to perform trustee duties, then joining trustees committed the breach of the trust. Order trustee to account, appoint a special fiduciary to take possession of the trust property and administer the trust. So with that being said, with my living trust, because this estate,
So you have an estate, a living trust where you're
Is it-
receiving income from?
no, this estate that we are administering right now, Mr.
An
Howard.
estate is a guardian, or it's involved in probate court. So does that mean you have an inheritance and an estate?
Okay, well, this is the problem. The person that Mr. Howard that you are referring to, different from the one in the living trust. Living trust, you obviously, you have beneficiaries that are inside of the living trust, so there's a problem.
Can you define trust for me, Mr. Howard?
Okay, well,
A trust is an inheritance
yes,
or money that's set aside for people to inherit or be
yes.
given. So do you have that money?
My beneficiaries are in the trust. I don't have, inside of my living trust, my beneficiaries, we have,
Oh,
that's the
it's your
problem inside of
living
this
trust.
court.
Okay,
My
that
children
doesn't
are in
apply to
here.
this.
My children are inside my living trust.
It doesn't apply to this.
Still, I mean, you can,
It's simply the law, Mr. Howard.
I know, and it's a law that I can invoke the DPP have parental immunity as well.
There's no such thing as parental immunity.
From the U.S. Department of Civil Rights, 2016, Dear Colleague letter explains things a little bit different.
I'm sorry, what letter?
2016 Dear Colleague letter,
Your colleague letter?
yeah, 8 pages.
Okay.
Okay, thank you. Any other questions for Ms. Howard?
Was there ever an agreement to not have child support?
No, there was not.
You're under oath.
She's answered your question, so. Do you have any other questions for Ms. Howard?
No.
Mr. Bregman, do you have any questions for Ms. Howard?
I have no questions from Ms. Howard.
So,
Okay. All right, Ms. Howard, you can go ahead and mute yourself. And, all right, so Mr. Howard, is there, we have closing arguments you can make, or you can make a statement and allow Mr. Bregman to cross-examine you. So which would you like to do? Do you wish to testify?
I got 15 minutes, right?
Do you wish to testify?
myself. No, but I,
Okay, so do you wish to make a closing statement? Then?
sorry,
So you don't wish to testify today? No? Okay. Mr. Bregman, do you have a closing statement?
We're gonna rely on that testimony, Mr. Vasquez.
All right. Mr. Howard, do you have a closing statement?
a personal identification identification that I want to be redacted. I have a long form fiduciary form that I wanted to be done. And I also have a sworn supervised administration of a trust that I want to get taken care of. But as far as the ability to pay, I haven't had in the last 3.5 years. I've had a possible charge. I have denials right here from different companies that wouldn't do it because of because of the background charge. I had a possible felony at the time. So for almost 4 years now, I've been denied. And in the last month, 2 months, I just got a job there with the Great Lakes Security. So I worked a couple times with them, and they have child support to take the money out of the check that just happened when I worked. I believe it was the last month when I had one last time there. But they're trying to get me in rotation in the schedule there. So I'm trying to get my after being taken the charge of, now I'm able to, without nothing pending, I can probably do more. But up to that point, though, it's just impossible to pay, and the impossibility to pay, I invoke that in Michigan is defense.
What's the basis of the impossibility to pay?
I've had background checks where I couldn't pass for 3 of those 4 years.
Anything else, Mr. Bregman?
I would just state that Mr. Howard could go down to the front of the court and ask for a referee hearing to have those child support amounts adjusted based on his job or lack of job or not being able to get a job. And until he does that, it's impossible for Mr. Vasquez to do anything but process the order that's in place. So Mr. Howard could go down to the front of the court and go through the procedure, but until that happens, we are dealing with an order that is in place and enforcing the order that's in place.
I have children I look after every day. Like
Say that again?
outside of this coming to court, because I come here probably twice a month for the last 3 years. And like, I'm really trying to be outside of it so I can maintain what I'm doing at home.
We gotta pay your child
Yeah.
support, and then you don't have to come to court. It's very simple. I have thousands of people that pay their child support and don't come to my court. All right, so it's finding of the court that Mr. Howard is guilty of failure to pay child support. He has an arrearage in excess of, as of today's date, $8,148.31. He has a de minimis charge of $151. I don't find the fact that he had a felony charge as a good enough reason that he can't pay child support, because I have tons of felons on probation who hold full-time jobs. I'm sorry, Mr. Howard, a lot of the information you provided does not apply to the civil court system. you're using language from the probate court that do not apply. So I do find that you're guilty of failure to pay child support. Sentence of the court was served 14 days in the Lenawee County Jail. You can be released upon the payment of $2,000. Court services.
So. I'm just putting my stuff up.
Yeah, that's fine.
I ain't doing nothing.
No,
special.
you're fine.
Got everything? Thanks.
One of the lot goes in the text.
Oh.
Yes, sir. Sir.
You good on crown?
Yeah.
Okay.
Yeah,
I just want to do it.
wait, let me make sure I get this. No, but I'm gonna. I'm gonna, hey, Jake. Will you get me a printout, because I don't have his last provided address on this printout, it's all wiped out.
Who is it?
It's, Sean Dickerson, the 2011 case,
AUN or AWN?
AWN. Thank you.
2011 case.
2011, yeah, I'll wait for you. Thank you. I mean, this is pretty simple. Hey. I killed him. Guilty. He went down to get me a printout. I thought I was doing mine in person too. I gotta get a printout because I didn't bring a printout up.
Do you want to start, Mr. Bregman, with paternities?
I print out some address line.
We're live on YouTube. All right, so let's see what I got in my waiting room. I got Madison has been here all morning, so we'll get her. Renata. I have a gentleman that's. Oh, connected. All right, I have a gentleman on an iPhone 12 in a house where the rooms look to be sage green, wearing a hoodie. What is your name, please?
Donovan Friel.
All right, that's So I was looking for Mr. Kincaid. I'm gonna pop you in the waiting room. All right, Madison, I need her to connect to audio. Ms. Underwood, I'm gonna do my paternity hearings first. And then I have one pickup, so I'll be with you in a minute, Ms. Underwood. Madison is not connecting, so. Let's see who else we got. Well, we're waiting for her to connect. I did send a chat message to connect. Audrey. Mr. Kincaid, be back in. All right, Mr. Kincaid, this is in the matter of Ambrielle Nicole Meyer versus Nicholas Xavier Kincaid, file number 22-49879 DS. I have Mark Brugman appearing on behalf of the Lenawee County Prosecutor's Office, 266065. Mr. Kincaid, this is the date and time scheduled for a motion for entry of order. Did you receive a copy, sir, of the judgment of paternity and support?
Yes, ma'am, I did.
All right, and you've had an opportunity to review that?
Yes, I have.
All right, and sir, there are two different areas. One would be custody and parenting time, and one would be child support. Do you disagree with either of those or object to either of those being entered?
I do not disagree with either of them.
Okay, so you're in agreement with the child support order as well as custody as placed in the
Yes.
judgment of paternity. All right, Mr.
Yes, ma'am.
Bregman?
Your Honor, as you stated, this is the date and time set for my motion for entry of the order. You did just ask Mr. Kincaid if he had objections. He stated on the record that he did not. Based on our motion, as well as Mr. Kincaid having no objections, we would ask the order be entered as presented.
Right. All right, so, Mr. Kincaid, I'm going to sign the child support order as well as the judgment. Going forward, sir, if you ever have a dispute or you wish to change child support or your parenting time, you would do that through friend of the court by scheduling a referee hearing or an income review. And then I would also advise you that if you ever move, you need to make sure you change your address with friend of the court, all right?
No, no problem. Would the friend of the
Right.
court be contacting you guys directly?
So the friend of the court is in the same building and they're kind of a division of the family division. So if you change your address, it goes into the system. Is that what you mean?
Yeah.
Yep. They handle all matters initially regarding custody, parenting time and support. And so they do to make those changes. All right, Mr. Kincaid, good luck to you. Thank you.
Thank you.
Still waiting for Madison to connect. Send her another chat message. Let's see. Sir, Madison, I'm gonna disconnect Madison and hopefully she logs back in. Because I think maybe she's walked away. So I'm gonna disconnect her and usually they'll connect again. All right, Ms. Pumphrey, can you hear me?
Yes, I can.
All right, this is in the matter of Audrey Jeanette Pumphrey, file number versus Jamie Lee McMurray, file number 22-49487 DS. I have Mark A. Bruggeman appearing on behalf of the Lenawee County Prosecutor's Office. And his P number is 66065. Mr. Bruggeman has provided the court a motion for entry of order with an attached judgment of support and friend of court order. So Ms. Humphrey, did you receive both of those?
Yes, I have.
All right, and there are two terms specifically. One would be the custody and parenting time provision, and one would be the child support provision. Do you dispute either of those?
No,
All right. So you have no objection to entry of this judgment of support.
no.
All right, Mr. Bruggeman.
Your Honor. Your Honor, as you indicated, this is the date and time set for my motion for entry of order. She just testified and stated on the record, she has no objections. We ask that the order be entered as presented.
Very good. I am signing the order and it'll be entered. Ma'am, going forward, remember that you're utilizing friend of the court services and that you need to keep your address updated with the friend of the court. All right.
All right.
All right. Thank you, ma'am. Have a good day.
You also. That was quick.
Yeah, it's always quick. About the same time it takes to get pregnant. All right. It's true. All right, let's see. I got somebody calling in. I have someone who's called in on a telephone. Can I ask what your name is, please? I have someone who's
Pablo
called
Flores.
in. Oh, thank you. All right, let me find you here.
I tried to sign into the app, but it just says I'm waiting.
It's okay. Oh, yep, there you are. All right, I just let you in. I just hadn't called your case yet.
Okay.
Oh, there you are. All right, so this is in the matter of Rosita Angelina Lee versus Pablo Flores III, file number 22-50048 DP. This is the date and time set for paternity arraignment. I believe Mr. Bruggeman is appearing on behalf of the Lenawee County Prosecutor's Office, P66065. You see, we need to change the paperwork so it doesn't say Burke Castleberry anymore. So, Mr. Bruggeman, you may proceed.
Your Honor, this is, as you indicated, this is the date and time set for Mr. Flores' paternity arraignment. Mr. Flores can either request genetic testing, or he can acknowledge being the father by way of testimony and indicating that he would sign the affidavit of parentage. So the two choices would be to request genetic testing, in which case we would prepare an order, this court would sign that order, and then the test would be performed, or you could acknowledge paternity.
I would actually want to go ahead and do the testing.
Okay. All right, Mr. Bruggeman.
So we are at this time requesting that you order genetic testing. We will prepare an order to that effect. We will get in contact with Mr. Flores to set up those genetic tests. It's simply a swab to the inside of the cheek. And when we get those results, Mr. Flores will have them. If this case comes back that he is not the father, this matter would be dismissed. If the case comes back that he is 99.9% the father, we will proceed with a pretrial.
Do you have any questions, Mr. Flores?
No, I do not.
All right. Thank you, Mr. Flores, and just make sure when you receive those communications from Mr. Bruggeman's office, you respond timely and get the DNA test done, all right?
Yes.
All right. Thank you, Mr. Flores.
Thank you.
You're all set. All right. Well, Mr. Friel, Madison's never called back in, so we'll just proceed because you've been patient waiting. So this is in the matter of Madison Lynn Rennell versus Donovan James Friel, file number 22-49902-3S. Sir, you are Donovan James Friel?
Yes, ma'am.
Now, sir, did you, and we also have Mark Brugman appearing on behalf of Lenawee County Prosecutor's Office, P66065. So, Mr. Friel, did you receive a copy of the motion for entry of order along with the judgment of paternity and support as well as the child support order? Did you receive all those documents?
Yes.
Have you had an opportunity to review all those documents?
Yes, I went over them.
Okay, now, sir, there are two areas that you can object to, one or dispute. One would be the custody and parenting time provision, and the second would be the child support provision. Do you object to either of those or dispute those?
I dispute the parenting time and paternity.
Okay, wait, paternity?
Or yeah, I wanted to. Madison keeps texting me saying that I'm not the father and that I should get a paternity test. So I don't know what I should do through that. And then if she is my child, what I should do with custody, I just don't know.
Okay, so, and you have these messages that say that it's not your child and you thought it was?
Yes, and I'm on the birth certificate, so I thought it was my child, but he keeps texting me and calling me saying that it's not.
Your Honor, this is a DS case, meaning when it was referred to us from the state of Michigan, attorney was already established. Whether that be by the way that they were married at the time of birth, or that he signed that affidavit of parentage. A lot of people will say signing the birth certificate at the hospital, that's the equivalent of signing the affidavit of parentage. So at this.
I know, but why would she tell me that I'm not the father?
Hold on, Mr.
telling me
Friel, just hold on a minute and just give me a minute. So, Mr. Bregman, I understand that, but he's now being informed. So I can set aside for good cause the default and order of paternity test.
You can order a test. I can't request that. You can order a test and we could perform those tests. And then what we could do is adjourn this matter pending those tests, but I can't request that. I got this referral.
I'm going to order it.
Thank you.
Okay, so Mr. Friel, what I'm going to do is order genetic testing, all right?
Okay.
So I'm going to order a genetic test. Now, Mr. Brugman's office, are you still on Treat Highway?
Yes, ma'am.
Okay, so Mr. Brugman's office will contact you to set up the time for you to take the genetic testing. It's just a mouth swab. And make sure that you timely respond and get in there and do it, all right?
Okay, do you know when I can do it, or the earliest convenience?
Mr. Bregman, I think you do that every so often.
Yeah,
right?
we'll contact you to get that test set up. And
thank
you've been in contact.
Okay, so you'll receive notice of when to take that test. I can't give you the date today, Mr. Friel. Thank you from Polk Jail. I'll be right with you. You're next. So Mr. Friel, when you get that notice, go in, do the genetic test, and then they'll set another hearing date and you'll get that notice as well. If you have any questions, Mr. Bregman's office phone number is listed on your paperwork, all right?
All right, thank you, ma'am. Thank you, sir.
All right.
Your Honor, just real quick, I just want to make sure this matter is being adjourned and not dismissed. We're gonna
Yeah,
adjourn
it's
it
gonna be
pending.
adjourned and we'll get another court date.
Perfect. I just didn't want this matter to be dismissed.
Nope.
Thank you.
All right, you're all set, Mr. Friel.
All right, thank you. Have a good day.
Thank you. All right, so I have a gentleman from, invite him. Who do you have from, as an inmate? I'm connected to audio. Can you hear me at Polk County Jail? Who is it? That was from Tennessee. Springman. Oh, there you go. Can you hear me now?
Yes, ma'am.
All right, what is your name?
Jamie McMurray.
All right, Hold on a second. All right, okay. All right, so, Jamie McMurray is your name?
Yes, ma'am.
All right, so we had called this case earlier, and I do apologize. Audrey Pumphrey had appeared. Miss McMurray, so this is in the matter of Audrey Jeanette Pumphrey versus Jamie Lee McMurray, file number 22-49487DS. Hold on a second. Hold on 1 second, I'll be right with you.
Okay.
All right, so Ms. McMurray, did you receive a copy of the motion and entry for order along with the judgment of support?
Yes.
Okay, so ma'am, when I called the case earlier, Ms. Pumphrey didn't object to any of the custody or child support provisions. Do you?
Are you talking about just me paying the child support?
Well, it would be the custody, parenting time, and child support. Do you agree with all those terms that are in this judgment?
I'm not sure. I didn't bring it with me, but I seen that they said something about $351 for the child support, and I'm going to court here in McMinn County for the custody part. I go on the 15th and my lawyer hasn't come see me yet about that, but I don't know if that has anything to do with this. I thought this was just for child support.
Well, all right, so the child resides in Michigan and was born in Michigan, is that correct?
Yeah.
Okay, so based on that, Michigan has jurisdiction over this child. So this order sets up a child support order. And then also, let me see. This gives Audrey Jeanette Pumphrey sole physical custody of this child. And then orders child support. What are you in jail for?
I was on probation and they violated me. I go out for parole soon. I don't know if I'm gonna make it though. So I don't know exactly when I'll be out. So
Okay, so are you in a local like jail, or are you in Tennessee Department of Corrections?
well, I am TDOC'd, but I'm held here in Polk County because it is a state holding facility. So they're holding me for McMinn County, but I'll have to do the rest of my prison stay here. But I am a TDOC inmate.
Okay, how long you been in custody?
Almost 10 months now.
Okay.
9,
And,
maybe it's 9.
what day did you go to jail? What was your date of arrest?
It was April 3rd, so it's almost been 9 months.
So you were taken into custody on April 3rd of 2022?
Yes.
All right, so do you object to Jamie Pumphrey having custody?
No, as far as I know, she has temporary custody until until I can get something else. So I don't know what I don't know what I'd be agreeing. I mean, I know that she has custody and I'm okay with her having custody and me paying child support. I don't have a problem with that. But whenever I get out, I do plan to hopefully be able to have visitations and stuff with my kids. And I just don't want to agree to something that I don't know I'm not sure.
Okay, so ma'am, the order that's proposed gives her physical custody. It gives parenting time at all times agreeable. So if you guys set up parenting time, that's fine. If you don't, then you can go to front of the court and request a parenting time schedule. But it also gives her physical custody and then a child support order. So do you agree to that or no?
Does the physical custody, does that mean forever or just until?
It gives it to her until such time as you petition the court to try to change it.
Okay.
Who is she to you?
She is the father of my two kids, his mother.
All right, so she has both your kids? Okay. So,
Yes.
all right, so do you object to this motion order or do you agree with it?
So I'm just giving her, I'm just agreeing to, I'm just sorry, I'm just trying to make sure that I don't say anything that would cause me not to be able to see my kids or anything. So I'm just saying that I agree to her having custody until I can get out and do the things that I have to do and the steps I have to take to get my kids back. I do agree to that until I get out, but isn't that called temporary custody?
This is not temporary custody, Ms. McMurray. This is physical custody. And if you want to change that, you're going to have to be able to show that there's a change in circumstances, that it's in the best interest of your children to be with you. You don't automatically get custody back.
Yeah, well, I know I have to take steps to get my kids back when I get out, but this isn't signing my rights away or anything to them, right? It's not.
No, you're not terminating your parental rights.
Okay. Then, okay, yeah, I agree to her having custody until then, and I agree to the paying the child support also. But I cannot pay child support until I get out, obviously, because I'm incarcerated right now.
So that's the next thing I'm going to tell you about. But do you understand? You don't automatically get custody back when you get out of jail. Do you understand that?
Yeah, I know I have to take steps, and I have a lawyer and stuff coming to see me for that, for me to start taking steps to get them back when I get out. I go to court on that on the 15th, but that's here in McMinn County.
On these children or on the?
On what? I'm sorry?
Is this one child or both?
It should be both my kids.
Hold on, let me look. Yeah, two of them.
Yeah, it is, you're right.
So, ma'am, what I would tell you though is that your case will be in Michigan, so make sure that your Tennessee attorney understands that your custody case is in Michigan, not Tennessee.
But as far as I've known, I have a custody case here in Tennessee that I go to court on that on the 15th.
I don't know. So, all right. So, ma'am, I'm going to sign this order. So the next thing, based on the fact that you have no objection. So the next thing I want to tell you is you need to mail to the front of the court or to me on the form your proof of incarceration and when you get out, so that we can stay your child support order while you're in custody. Do you understand that?
Yes.
Okay, if you don't, and you try to do it after you get out, it may not apply. So you need to get some kind of proof of incarceration from Tennessee Department of Corrections showing when you were arrested and when you're getting out, all right? And you need to send that to us. And then when you get out, you need to provide that documentation to us as well. Do you understand that?
Yes, ma'am.
All right. Now, do you have any questions?
No.
Okay. All right, so Mr. Brugman, based upon the fact that she doesn't dispute any of the provisions, I have signed the judgment of support and paternity and support order. Is there anything else, Mr. Brugman?
No, Your Honor.
All right, ma'am, I wish you the best of luck, all right?
Thank you.
All right, thank you. So. You're all set. I'm gonna disconnect you, ma'am. All right, so let's see, in the matter of Kamisha Renee Bridges versus Caleb Ray Slusher, file number 22-49852 DP. This is the date and time scheduled for motion for entry of order. Mr. Bruggeman, I do not have him in my waiting room, and no one stood up in the courtroom. I'm looking. All represented by the court on October 12th, and I have a proof of service on 9/20 of 22 in Saginaw, Michigan. So Mr. Bruggeman is appearing on behalf of the people, case 66065. Mr. Bruggeman.
Your Honor, as you correctly indicated, this is the date and time set for our motion for entry of order. All parties were served with today's hearing date. No parties have appeared. Based on their failure to appear, we move to have our order entered as presented.
Sign, enter the order. And we have all right, in the matter of Anne Marie Ben Scooter versus Chad Derek Kirkpatrick, file number 22-49920 DS. I'm Miss Ben. Oh, there you are. Okay. What did you say?
So I'm not the entrance.
All right, and you're Chad Derek Kirkpatrick. All right, you want to come up here? This is file number 22-49920 DS. I have Mark Bruggeman appearing on behalf of Lenawee County Prosecutor's Office, case 66065. All right, so Ms. Ben Scooter and Mr. Kirkpatrick, welcome. So did you receive a copy of the motion for entry of order along with the child support order and the judgment of support and paternity? All right, Mr. Kirkpatrick, have you had an opportunity to read and review it? And Ms. Ben Scooter, have you?
Yes.
Okay, do you have any questions, Ms. Ben Scooter? Mr. Kirkpatrick? Do you object to any of the provisions in it regarding custody, parenting time, or support? Mr. Kirkpatrick? Just parenting time, and what about you? No? All right, so I'm going to mark the box that the defendant has disputed the custody and parenting time order, and then I'll take child support with it. So what'll happen is this will be set for a referee hearing. You'll receive a notice in the mail to appear for that referee hearing. Make sure that if you have any documents you wish to provide to the referee beforehand, you drop them off, like maybe the week before or a couple days in advance, so the referee has everything. And then that will be via Zoom. If you have an attorney, make sure they're aware of the date and time. And I've signed the order and requested that. It could be 4 to 6 weeks out. I'm not sure how fast we're scheduling referee hearings, but understand, sir, a child support order is in place. And so even No, what I'm just saying is even though there's an objection, just make sure that either make some payments online or save the money up so that you can pay it, because otherwise you'll end up in a arrearage, all right?
How do I go about paying like online? Or do I just bring up money each year?
You can, there's a form down in front of the court that gives you all the information on how to pay online. Okay? All right, so make sure you keep your address updated with friend of the court, and I wish you both the best of luck.
Thank you.
Thank you. All right. All right, in the matter of Julie Ann Smith versus Mark Anthony Reese, file number 22-49977 DP. This is date and time set for a paternity hearing in this matter. Would Mark Reese by any chance be in the courtroom? No. All right, I have a summons, but I show a proof of service showing that Mr. Reese was served on October 14th of 22. With the summons along with today's hearing. He is not in my waiting room. He is not in my courtroom. Mr. Bruggeman.
Your Honor, as you indicated, this is the date and time set for Mr. Reese's paternity arraignment. He was served. He has failed to appear by here in person or by way of Zoom. Based on his failure to appear, we move to enter a default judgment finding him as the father.
All right, Mr. Bruggeman, I will sign that default upon presentation. All right, anything else regarding those paternities today, Mr. Bruggeman?
We do Grinnell versus Grinnell, and I just did check.
We did.
I just did check it out. Okay.
Yeah, we did. And then Mr. Dickerson, is that, what is your name?
Great.
Oh, Devin Riggs, okay. Mr. Dickerson?
You should be in jail, Judge.
Oh, Miss Adams, can I have Mr. Dickerson? He's a short.
Okay.
Hey Becky, are you at your desk?
Yes, I'm calling, Judge.
All right, and I have Mr. Rakes in the courtroom. Devin Rakes.
Judge Stephen Rakes is scheduled for tomorrow.
8:30 tomorrow.
I thought it was today.
It's okay.
8
Better
a.m.
early than late. Yep.
8
tomorrow morning
a.m.
at 8
tomorrow.
o'clock. 8 o'clock. All right, thank you. Sir, you're William Randall's, right?
Yes.
Okay. You're fine. You're a little bit early. We're just waiting for Mr. Decker Marcos in, all right?
Okay.
Just waiting for the jail to turn on. Have a blank screen. I haven't had this many people in my courtroom since my last jury trial. Yeah. Even Wednesdays, I don't have a whole lot of people in
He's kind of weird sitting in here.
here. No, right? Becky, the jail is not, the video or audio is not on.
I'll check what's going on.
Mr. Fleming, are you here on?
The Randalls, please, Judge.
Okay, all right. What is your name?
There you go. Thanks.
Jeff. Jeff, what is that young lady here for?
She's here for jury duty. She's on panel B. They told her to come up here.
Okay, so go, ma'am, so did you call last night after 5?
And they still said we're in panel B Tuesday.
And there are a bunch of jurors down there?
I didn't see anybody, I met a lady in the hallway, I was like, somebody, like, where do I go? And
Sierra, Judge Olsaber doesn't have a trial, right?
Correct. There should be no trials today.
Yeah, so it got canceled. I'm pretty sure, I'm sorry if you missed the message, but you're all set. I don't know when the next trial is, but thank you.
I'll go back, no problem.
All right, thank you. All right, I have, is that you, Mr. Dickerson?
Yes, ma'am.
All right, let me get your paperwork. All right. So this is in the matter of Sierra Lanai Colburn versus Sean Davis Dickerson. Mr. Dickerson, we were here yesterday on a friend of the court show, or wait, is this a new one today?
Oh, he was picked up on a bench warrant. He pled not guilty on both failing.
Yes, for court appointed counsel. All right, so Mr. Dickerson, we're just waiting for your attorney. So Ms. Adams,
He wanted an attorney.
he did ask for one for the trial.
Did he?
Yeah, so Mr. Dickerson, you had waived an attorney, but then you had asked for one for the hearing, is that correct?
Correct. Correct.
He pled not guilty on both today, so we set up for hearing.
Okay.
And then
Judge.
he had asked- Yes,
Rhonda sent a message that she's on her way in.
okay. Well, we're just waiting for her. All right, so Mr. Dickerson, I'm going to change your screen name real quick. And Ms. Adams, I also need Michael Dagger goes in.
He's here.
All right, your client's here, and then Mr. Fleming is online on
Okay.
Zoom. Are you ready to proceed?
Yes, sir.
Okay. All right, so Mr. Dickerson, just bear with me for a minute. I'll find out who this iPhone person is. Mr. Dickerson, if you just want to hang out for a minute. All right, I have someone who's joined on an iPhone. I'm going to send you a request to unmute and ask you who you are. And I'm going to send you a request to start video. Otherwise, I'll have to remove you because I don't know who you are. All right, you're not responding, so I'm just going to pop them away. All right, this is in the matter of the people of the state of Michigan versus William Jr. Randalls, file number 22-20779FH, and Michael Dagger Margosian appearing on behalf of Mr. Randalls. I have Christopher Fleming appearing on behalf of the people. Is that my jury room? Oh, no, you're downstairs. This is the date and time that was originally scheduled for a jury trial. And Mr. Dagger Margosian, you make the court aware that at this time your client wishes to enter a plea. Is that still?
That is accurate, Your Honor. Yes.
All right. So, Mr. Randalls, you want to raise your right hand for me, please? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, so Mr. Dagger Margosian, could you state the record or state on the record the plea, please?
Your Honor, the plea will be that Mr. Randalls will be pleading guilty to one count of simple assault, and in exchange, the information will be dismissed.
Yeah, speak up a little bit.
I'm sorry, Mr. Randalls will be pleading guilty to one count of simple assault, and in exchange for that, the original information will be dismissed.
All right, so Mr. Fleming, he's going to plead to an added count 2 simple assault, so you'll be amending the information.
That's correct, Judge.
All right. And that is a 93-day misdemeanor, and any other terms of the plea?
Well, no, but we'll be addressing a bond condition immediately after the plea, but nothing further.
That's fine. All right, so Mr. Randalls, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 2 simple assault?
Yeah, yes.
Okay. Are you satisfied with Mr. Dagger Margosian and the advice that he has given you?
Yes.
Do you understand the maximum penalty for this offense could be up to 93 days in jail and a $750 fine?
Yes, ma'am.
All right. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any possible sentence with the court. Is that correct, Mr. Fleming?
That's correct, Judge.
Is that correct, Mr. Dagger Margosian?
Yes, it is, Your Honor.
And Mr. Randalls, is that correct as far as you're aware?
Yes.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury, and in fact, we were scheduled for trial today. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have a prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yeah.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you understand that?
Yes, sir.
Do you have any questions about the rights that I've given to you? All right. So, sir, how do you wish to plead to the charge that on or about February 17th of 2022 in the city of Adrian in the county of Lenawee, that you did commit the offense of simple assault?
Yes, ma'am.
Do you plead guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Fleming?
No, Judge.
Mr. Dagger Margosian?
No, Your Honor.
Has your attorney promised you any particular sentence or estimated what your sentence will be?
No.
Okay. Is it your own choice to plead guilty?
What's that?
Is it your own choice to plead guilty?
Yes, ma'am.
All right. So, sir, on February 17th of 2022, were you in the city of Adrian in the county of Lenawee?
Yeah.
And were you in the company of an individuals who had initials of TK?
Yeah.
Okay, and did you assault them in some way? Did you push them, pull them, slap them, knock them down, punch them, stab them? What did you do?
It's a complicated thing.
Well, I don't want to-
I guess it was hands-on, so I'm.
No, stop, hold on a minute. Mr. Dagger Margosian, if you'd like to,
Sure. Mr. Randall, on that date, on February 17th of this year, were you, when you were in the city of Adrian, that was in this court's parking lot?
Yes.
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 And at that time, did you put your hands on Ms. King?
Yes.
In what way? In what way?
I was trying to grab my truck keys from her and she fell, I fell on top of her.
And you had your hands on her back of her neck, head area?
I guess I don't remember. I was drinking, so it could have been, yeah.
So-
I'm just,
okay, so hold on a second. So, Mr. Randos, I'm gonna let your attorney speak with you quietly for just a moment.
Okay.
Mr. Reynolds, did you put your hand on Ms. King's back of the head neck area?
Yes.
And was that unconsented to?
Yes.
And that was with the intent to either injure or harm or embarrass.
Yeah.
Okay. I think I'm satisfied.
Mr. Fleming, are you satisfied?
You are satisfied, Judge.
All right, has court complied with MCR 6.302 B, C, and D? Mr. Fleming,
Yes, Judge, thank you.
Mr. Dagger Margosian?
Yes, Your Honor.
Accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the District Court Probation Department for a pre-sentence investigation. Ms. Adams, I'm sure you sent it to me, but could I have a sentencing date, Ms. Adams? It's gotta be like 6 weeks out or more.
Yes. December 29th at 8:15.
Mr. Dagger Margosian, is that date acceptable for you?
Yep.
Okay, all right, thank you, Ms. Adams. All right, so, Mr. Randalls, I'm going to set this matter for sentencing on December 29th at 8:15. Ms. Adams, could I get a notice for Mr. Randalls?
Sure.
So, Mr. Randalls, tomorrow or Friday, or even tomorrow, if you, or even today, if it would be easier for you, I need you to go check in at District Court Probation,
Right.
and we're gonna send paperwork down to them.
Okay.
They're gonna set up a time to meet with you. When you meet with them, just be truthful about your background, the events that occurred. They'll do a probation sentencing report, and I'll get that, a copy of that to Mr. Dagger Margosian, and he'll review that with you. And then we'll see you back on December 29th at 8:15. So, Mr. Randalls, is it easier for you to come in person, or do you want to appear via Zoom?
It'd probably be easier for me to do Zoom because I don't have a driver's license, so
And,
it's hard to find rides sometimes.
okay, so Mr. Dagger Margosian, any objection to
No.
Zoom?
No, thank you.
Okay, all right, and Mr. Dagger Margosian, you wish to address a bond condition?
Your Honor, there is a bond condition for no contact with Ms. King. She is in court today. She's here in support of Mr. Randall. She has relayed to me, and if the court wants to hear from her, she'll say the same. She's relayed to me that she strongly wishes for this no contact condition to be removed. Mr. Randall's, for this whole pendency of this case, has not been able to go back to his home. This is where all of his.
Well, he's gone a couple times.
He hasn't been able to go back and reside at that home, which is where all of his belongings are. Throughout this whole, again, throughout the course of this case, Ms. King has not only is supportive of Mr. Randall's today, but she's been supportive throughout the whole process. So he's obviously owned up to what occurred back on in February. He wants to just kind of move past this issue, and I think the reunification is step number one, and certainly I wouldn't be making this request without the support of Ms. King, but she's here in support of that request.
All right, Mr. Fleming, any objection if I take testimony or have Ms. King weigh in?
He will leave it in your Honor's discretion.
All right, Ms. King, you want to step up to the podium? Push.
Just push it.
Yeah, there you go. All right, so ma'am, step up to the podium. So you've heard the, could you state your name for the record?
Taylor King.
All right, Ms. King. So you heard the statement that Mr. Dagger Margosian made today, and he's asking that the no contact bond condition be removed. What is your preference on that?
I want it to be removed.
Okay. Has anyone threatened you in any way?
No,
Has anyone promised you anything to request that?
no,
Are you in fear?
no.
Okay. And do you wish, all right, so you wish me to remove it completely?
Yes.
Mr. Fleming, any position?
No, Judge.
All right, so I'm going to remove the bond condition that does not allow contact between the parties. But Mr. Randall's, your other bond conditions remain in place, okay? So I'm gonna need you to stick around today so we can have you sign those, okay? All right, do you have anything else? No? All right, so as I said, we'll see you back for sentencing on December 29th at 8:15. I need you to go check in today at probation since you're here on the first floor.
All right, I gotta wait, you said, for
Yep, so the first thing you're gonna do is you're just gonna hang out here. My staff will prepare your bond conditions. You're gonna have to sign them and we'll get you a copy of them. We'll get you a notice of hearing for sentencing. And then I need you, while you're here, to go down to district court probation. Because it's a misdemeanor, district court probation will be monitoring, okay?
Yep.
And check in there and they'll set up a time to meet with you to prepare a pre-sentence report.
Okay.
Any
Sounds good.
questions?
Nope.
All right, anything else, Mr. Fleming?
No, Judge, thank you. Have a good
Mr.
day.
Dagger-Marcos?
No,
All right,
thank you.
very good, thank you. Thank you, Mr. Dickerson. All right, I have this iPhone, I don't know if it's Rhonda Underwood. All right, I have someone who's connected with an iPhone. Can I ask who you are?
Yes, my name is Sierra Rojo. Can you hear me?
Sierra Rojo. Yes, I
Yes.
hear you. You said
Okay.
Sierra Rojo?
Correct.
Okay, ma'am, can I ask what you're here for?
Mrs. Pelham asked me to get on this Zoom call pertaining to child support for Sean Dickerson.
Oh, she's Colburn, Sarah Colburn. Okay, all right.
Yes.
So ma'am, how do you spell your last name?
ROJO.
All right, and I am going to, we're just waiting to start the hearing. So, I'm gonna change your screen name and I'm gonna pop you in the waiting room and we'll bring you back in just a moment, all right?
Okay. Thank you.
Thank you. Mr. Dickerson, I'm gonna pop you in the waiting room and bring you back in too.